So good morning, everyone, and thank you for coming. Welcome to the Worldwide Legal Services for High Net Worth Individuals panel. My name is Alessandro Varrenti, and I've been given the privilege of being the moderator of such distinguished panel speakers. We regret not to be as many as we would have liked to, but I think we'd rather start, and maybe as we go along, other colleagues or interested people will join. I would like to start by thanking the organizers and the ILF, obviously, and in particular Ivanian and Partners and our friend and colleague Vasily Torvanovsky for making this possible. We have, in fact, a colleague from Ivanian and Partners to the very right. Julia will talk about some very interesting things in a few minutes. The structure of the panel contemplates a short presentation by each of us in the range of roughly 7 to 10 minutes. We would like it to be very interactive to the extent possible, so please feel free to step in, make comments or ask questions as we go along. Let me also introduce the panel speakers, if I may. We have Saverio Lembo from Bar & Carré from Switzerland. Saverio will speak about Swiss anti-money laundering laws, present and future. We have Julia Czechmarovia from Ivanian and Partners, and she will talk about foreign currency exchange, international tax, and other regulations of transnational affairs of the Russian residents. Very interesting topic. And we have, to my left, Dr. Hardy Fischer and Carl Binder. One is, Hardy is from the firm P&P Pollitt and Partners in Germany, and Hardy comes from Berlin. He will talk about foreign investments in Germany. And Carl Binder of Wolf Theis in Austria, a very distinguished firm, will talk about tax implications of real property investments in Austria. Then we have Olivier Peclar of the firm Bonin Vadlutzel and Partners in Geneva. Then we have, of course, Martin Lewis of Rubenstein Phillips Lewis in London. Martin will talk about using common law trusts as a tool for controlling and protecting private capital. And then we'll have, last but not least, Silvia Cietko of the Croatian office of Wolf Theis, talking about real estate investments in Croatia. And then we have two very distinguished guests, two bankers. One is Andrei Babian, who represents one of the biggest banks in Russia, Alpha Bank. He will talk on programs that provide clients with banking services and immediate referrals, if needed, to law firms, which is very interesting to most of us. And Dmitry Galkin will describe similar services provided by Gazprom Bank. My own subject is the regulatory environment concerning anti-money laundering and know your client compliance. I will try to make this as interesting as possible and without being too technical to the extent possible. I do have some slides. Let me see if I manage to work this out. Can everybody see the slides? Okay. Let me say that I think it was hard, at least in my own view, it was hardly predictable years ago that regulations concerning money laundering would have been so important to the, and in fact, it seems to me that to a certain extent, the importance of these regulations seems to have overtaken the importance of business in many a case. They have become a very difficult subject to deal with, at least in my own country, which is Italy, because of the many papers and documents the clients are supposed to sign, and the waivers and the compliance forms and documents that you need to give to clients even before you get started. And in my own view, which is strictly personal, I think we've gone too far. We've gone from one extreme to another. It used to be years ago that nobody knew, or people could hardly knew where the money would come from. And now it seems that governments have, in our own case, in the case of lawyers, have shifted the burden of looking into these sort of things upon lawyers. Italian law, which obviously has been enacted in furtherance of the third European directive on money laundering. I think Martin will talk about the draft of the fourth European directive in a few minutes. Italian lawyers are supposed to make a number of checks and investigations at the time when they receive, at the time when they're hired. And even the mere suspect of, the mere suspicion of something wrong compels Italian lawyers to notify the authorities about what they feel could be wrong in any potential transaction. And this includes the incorporation of companies from that are owned by foreign residents, transfer of capital, obviously, and acquisitions in general, not to mention acquisitions of real estate. So it's not only complicated for us these days, especially considering the crisis and the reduction in the workload that we've all suffered from in recent years, to try and go out and get some decent assignments, but then once you get an assignment, you have to complicate that by adding and getting the client to understand he has to fulfill all these formalities. Well, this being said, it's my own personal view. Let me take you slowly but quickly through some of the regulatory procedures and the legal framework. Basically, in the anti-money laundering, the AML and the Know Your Customer requirements are such that banks, financial institutions, non-financial businesses, and professionals, that is, ourselves, have to verify the identity of customers in the case of transactions or the establishment of a new professional relationship. That is a very broad definition, so the real question and issue is where you draw the line. We don't necessarily know, and the risk is that many people, in doubt, go too far and risk to create a problem where probably the problem should not necessarily be created. Our legal framework consists of a legislative decree that was passed in 2007 in furtherance of the European Directive number 60, 2005, which, as you all know, is the third anti-money laundering directive, and the legislative decree of 2007, number 109, in furtherance of the European Directive on terrorist financing in country whose actions threaten international peace and security. Just a few words on money laundering. Money laundering, as we all know, consists basically of three phases. One is the placement phase, the second is the layering, and the third is the integration. The thing about my own country is not necessarily what these steps are about, but what a public prosecutor or the financial police may think that you're doing or you've not done. So the threshold issue is you not only want to be sure that you're doing nothing wrong and that you've complied with the procedure, but to an extent you have to put yourself in the shoes of others and look at these things the way they would, which is very very difficult to understand in a way, and somewhat scary, because there are theories about plots and things that prosecutors in particular think that you may be doing, especially when it comes to lawyers and accountants. We as lawyers are also bound to keep something that we call Archivio Unico Informatico, which is sort of a classified folder of people and transactions that we work with. Especially when it comes to transactions of a certain type, you want to exercise a certain type of care in making the risk assessment. There is what we call a ordinary due diligence type of work that we're supposed to conduct, and then higher due diligence that we're supposed to run in cases where the transactions on which we're working exceed the threshold of 15,000 euros, which is minimal. So in essence, the high-level due diligence is practically always applied. And the due diligence is fundamentally aimed at identifying the beneficial owner, the ultimate beneficial owner. Now, it has happened to me in a number of cases that, and I think Julia knows what I'm thinking of, it was hard to identify the ultimate beneficial owner, and getting banks especially to understand that if the money comes from a country which is part of the European Union, that should be sufficient evidence that the transaction is clear and that there's nothing wrong with it. But I've seen cases where the bank has asked me a number of questions concerning what is behind the transfer that you received from Cyprus or Austria, and where did the money come from, and where was the money sent to Cyprus or Austria or whatever. In some cases where we have money coming from Dubai, that's the beginning of the end, because that is considered to be a grey list, and you get all the antennas around the potential transaction. So you do want to be extra careful, and in fact, all the structures that we've tried to put in place at some point, where, for example, the money would go from Dubai to Austria or to the UK and then come to Italy, have not proven to be sufficient, because banks and other institutions have always asked me, for example, okay, fine, the money came from the UK, but then initially it came, it was sent from another country, and then from there from Dubai. So who's the beneficial owner? And then in the end, it seems to me that there is a big hole, a big gap in the legislation, because I've seen cases where people resort to CCAVs and sectors of CCAVs. As you probably know, CCAV is a company that can have bearer shares, and if you incorporate a company, a CCAV in Luxembourg, and you dedicate a specific sector of a CCAV in Luxembourg to run a specific transaction, there is no way that you can identify the beneficial owner. Now, in such a case, I have witnessed the unbelievable, which is, in our own country, regulators have come in and said, okay, the burden of proof is shifted upon you to prove that the transaction is clean. So just because something comes from a CCAV in Luxembourg, there is the presumption that the transaction, that there's something wrong with the transaction. And to me, that is a paradox and a legal absurdity. I think I'd probably stop here, if I may now, and I will hand over to Saverio, if Saverio feels comfortable to start now.
Thank you, Alessandro. Yes?
Is that okay?
Yeah, that's perfect. Thank you. Good morning to everybody. I hope you can hear me. Alessandro, can I have the slide? What I'm going to talk about today is a little bit the same subject as Alessandro, and the compliance requirement for financial intermediary, and more especially an overview of the upcoming amendments of anti-money laundering legislation in Switzerland. I'm happy to tell you that I'm not a compliance officer or advising client in compliance. I'm a business crime defense lawyer. So I intervene when the fire already started burning, which is funnier, I would say. So I rather see how to extinguish the fire instead of how to prevent it. But what I'm telling you right now will tell you a little bit the background and what will happen in the next months in Switzerland, because there are going to be upcoming amendments with significant consequences at an international level. So first of all, who is subject to the law on anti-money laundering is financial intermediaries. Financial intermediaries under Swiss law means banks, security dealers, asset managers, etc. Also lawyers, if they do not practice the traditional activity of a lawyer. So if a lawyer sets up offshores, he will be submitted to this law. So I've tried to summarize the requirements and the due diligence requirement, and you will see that they pretty much match with the one that were described by Alessandro. Of course, you have to establish the identity of the beneficial owner, and some of you, if you have the experiences with Switzerland, you're familiar with the Formula A that you have to sign when you open an account in Switzerland. In which the holder of the account has to tell who is the beneficial owner of the account. There is, of course, a duty to clarify the nature and the purpose of the business relationship wanted by the customers. And in this respect, there are particular risks, and the Swiss legislator says that when there are increased risk, the clarification must be more important and more detailed. And these increased risks appear when you're dealing with, for example, with a PEP, a politically exposed person. I'll give you an example of that later. And then, of course, you have to keep the records and transaction for a minimum of 10 years. Also, another important thing in the landscape of anti-money laundering regulation in Switzerland is the duty to file suspicious activity reports, as you also have in Europe. Just for you to know, in terms of statistics, last year in 2014, 1,753 suspicion activity reports were filed with the Money Laundering Reporting Office of Switzerland. And out of this number, you'll have 72% of these suspicion activity reports, which gave rise to criminal proceedings started by the prosecutor. Now I'm going to run you through the amendments that are about to be enacted in Switzerland. And as you probably know, the Financial Action Task Force has issued a recommendation in February 2012. And Switzerland, like the other countries, also is implementing these recommendations. So the most significant amendments in terms of combat against money laundering is the creation of two crimes associated with tax. And I will tell you about that after we have seen the other ones. As in the future, if tax offenses, qualified tax offenses are committed, this would be a predicate offense for money laundering in Switzerland, which means that banks will report to the MROS and it will start criminal proceedings in Switzerland if some tax offenses have been committed. The other modification and amendments that I wanted to highlight here, they're listed on the screen, but maybe one which is of actuality is the increased due diligence requirements regarding PEPs, politically exposed person. The list of PEPs has been extended, and very interestingly, the person exercising an important function in an international sports federation will be regarded as PEPs and will be under close scrutiny as in the next months. You've seen what is happening with FIFA recently. I mean, this law will not help the people who received money on Swiss bank accounts. Another peculiarities of Swiss law and in the amendments is the increased due diligence in transaction for cash payments exceeding 100,000 francs. I told you before that only financial intermediaries were subjected to money laundering regulation in Switzerland. In the next months, it will be also, this law will also be applicable to people who sell, or shops who sell jewelries or watches, etc. They will no longer be able to accept payment in cash of more than 100,000. If they do, they must have a written track of the sale, they have to clarify the background of any unusual operation, and they have to inform, they have to file suspicious reports to the money laundering office in Switzerland. So you can imagine a watches seller doing the due diligence when he's selling his Rolex. So the only way to avoid that for the Swiss watches or jewelry sellers will be to accept a payment by transfer of electronic transfer of money, credit card or bank. I'd like to run you quickly through the two main provisions that will, and two main amendments in the money laundering, which are the predicate offense as tax offenses. To make a very short story of a long issue, in Switzerland, if you want to commit, if a money laundering offense is committed only if the predicate offense is a crime, and a crime under Swiss law, it's 3 years of prison. Currently, today, if you do not declare your money, or if you commit a tax offense, it is not regarded as a crime under Swiss law. But it will, as from the 1st January 2016, which means that if banks know that they are hosting accounts which are the product of tax offenses, they will have to report that to the money laundering office of Switzerland, with all the consequences that you can imagine. You're familiar with the Egmont Group. Also, when you put in the machine your name or the name of the client, it means that all the financial international units of the Egmont Group countries, and we are talking of more of 100 countries, will be able to know the name of the client. So this is a significant change under Swiss law, because there might be, I told you that there was 1,700 suspicion activity report last year. This year, next year in 2016, we will see what happened. I've asked the question to friends who are bankers or compliance officer in banks, and I've asked them question like, how are you going to apply this rule? Because you'll have to control and to be a specialist of tax law of every country in order to know whether it's a tax offense in the law. And their answer was, we are no longer accepting undeclared tax accounts, funds. That's the practical answer. I'm not sure it will be applied by all the banks, but they will have a hard time to apply this provision. Another detail I have to say is that the tax offense should hit a material threshold of minimum 300,000 francs of subtracted tax per taxation period. So I've put you on the screen, and I will finish with this because my 7 minutes have elapsed. Just to tell you that this is an important change, that there are questions such as when is a money laundering offense committed, or how is the threshold calculated, which will be a headache for bankers to apply. I predict that the bankers will be, I would say, cautious, and in case of doubt, they will rather report than not report. But it will be interesting to see how the banks and how the lawyers and how the authorities will interpret and defend the clients who have problems like this. Of course, if you have any question on the topic, I'm happy to answer them after everybody has talked. Thank you for your attention.
Thank you very much, Saverio. And I think we'll now hand over to Julia. Julia, you ready to start?
So, good morning, ladies and gentlemen. Thank you for being with us this morning. And because of short of time, because of time pressure, I have to walk you through very quickly through the topic, which is very important now. New trends in currency control and taxation in Russia. Sorry. Yes. First of all, we will speak about currency control liberalization and new reporting obligations. Then we go to so-called Russian FATCA, and we will end up with controlled foreign corporations. So currency control. Currency control, it's a thing which is very specific for Russia. I hardly could imagine that Western Europe or the US have something of this kind. But many years ago in 1992, the purpose of currency control was to protect internal currency market and to support balance of payments. Time passed, and now currency control looks more like a rudiment or even obstacle to developing free market and free trade. So last year, 2014, saw a lot of amendments to currency control legislation, and we will speak about some of them, very crucial for our private clients. First of all, I need to remind you that before 2015, there was a very short closed list of the transactions which were allowed to make through the foreign accounts opened by the Russian currency residents. I just want to remind you that Russian currency resident, it's absolutely different thing than Russian tax resident. Please don't confuse these terms. So go back to Russian residents. So in 2015, we have a widened but still closed list of the transactions, which is allowed for Russian currency residents to make through the foreign bank accounts. Just for example, now you can receive payment for lending your real property abroad, or to receive on your foreign bank accounts interest on your foreign deposits. But still we have restrictions, which is unfortunately, they're very important for our clients. Just imagine if we have a client who wants to invest abroad in foreign corporation, and he has foreign securities and wants to sell them, you need to keep in mind that now all the money received from the sale, he needs to receive on their Russian bank account, and it might be very inconvenient. We also have another restriction, but I think it's very reasonable, especially when we fight corruption. State officials, municipal officials, so-called PEP, politically exposed person, they are prohibited to have foreign bank accounts at all. So let's speak about currency obligations for currency residents. Some of the obligations they exist for years. For instance, all the Russian residents who open, close, or change their foreign bank account, they must notify the Russian tax authority about their foreign accounts. Usually Russian residents comply with this requirement, but sometimes, of course, sometimes they're not. But the main problem is practical now, and it's very unexpected one. And there is no legal ground behind it. A legal our tax authority decided to create electronic database of all the notification. It's a very good idea, but it turned out that banks decided to rely on this electronic database, which is just copy of the papers submitted by our clients to the tax authority. And because all the information typed manually, and there are a lot of mistakes in this database, but banks still rely on it, the result. Sometimes they freeze transaction just because a paper notification contradicts the electronic database. And I want to stress that not all the banks use this practice. So For instance, Gazprom Bank and Alpha Bank, they don't. And speaking about new reporting obligation, since January 2015, similar to all Russian legal entities, Russian residents have to report about all the transactions they made through their foreign bank accounts. And it may be a real problem, not just reporting, but just to meet the requirements of the tax authority. At this moment, I just want to stress that at this moment there is no reporting procedure approved by the tax authority. And what is nice, there is no liability for non-compliance. A few weeks ago, the Russian tax authority posted a newsletter on their website where they just waived the liability of Russian residents who don't comply with this reporting obligation in 2015. But the situation will change in 2016 because reporting procedure now is developing and will be approved for 2016. Let's speak about let's go to developing tax control and Russian FATCA. In 2014, there will be approved a new law. We could divide it into parts. The first one helps Russian banks to comply with FATCA. FATCA is U.S. Foreign Account Tax Compliance Act. Under this act, all Russian banks have to report the information about U.S. citizens and about U.S. tax residents to U.S. IRS, its Internal Revenue Service. And I just want to remind you that if you have clients which might be qualified as U.S. citizens or U.S. Tax residents, just to remind them, please, that they need to disclose this information to Russian banks. If they fail to do it or submit wrong information, unfortunately, they may face problems with Russian banks. For instance, if banks have reasonable doubts that the information submitted is wrong, incorrect, or fraudulent, they may refuse dealing with such clients or just freeze transaction or freeze the account. Another part of the law, it's a real Russian FATCA, because Russian government decided to follow the U.S. Government steps, and now there is an obligation for foreign financial institutions to report Russian government about all the transactions, about all accounts, held and by Russian residents, and about all the transactions. Unfortunately, as always, we don't have reporting procedure at this moment, and we don't have liability for non-compliance. But I think it will work since 2016. And the last topic I want to discuss with you today is controlled foreign corporations. As you know, before 2015, Russian residents who had shares in foreign corporations and had to pay taxes only on distributed income, I mean dividends. But since 2015, everything changed. And again, we following the U.S. experience, the Subpart F income taxation and controlled foreign corporations treatment. Sorry, I'm so sorry. So now we have two new terms, two new institutes. First of all, controlling persons and controlled foreign corporations. Controlled persons, Russian residents, and now I'm speaking about tax residents and about tax consequences. So Russian tax residents, if they have more than 10% of shares in the foreign corporation, they have to report about it to the tax authority. And now we have the first deadline, so June 15, 2015. But at this moment, we again don't have reporting procedure, but the government promised to approve it as soon as possible before June 15. Next obligation is taxation. So if controlling person owns more than 25% of the shares in the foreign corporation, or more than 10%, and together with other Russian shareholders, they have more than 50%, they have to pay income tax on non-distributed tax, so-called deemed distributed tax. So, and this is I think, the main problem. And you need to speak with your clients and discuss this new obligation, because they need to report about their shares, and they need to calculate the gross income and then the tax. Of course, there are some exclusions from this obligation, but unfortunately, I'm running short on time, and if you have any question, I will be very happy to discuss it during the Q&A section or just after this session. So thank you very much. Thank you.
Thank you, Yulia. Very interesting. I think we should now hand over to Hardy Fisher. Is that okay?
1-1? Yeah, it works, okay. And I need that, okay. Yeah, thanks, Alessandro. I will talk about foreign investments in Germany, and particular from a tax perspective. And I want to do that actually by using oh, now it works, okay. I want to do that actually by using an example, and you can see that example here on the slide. Let's assume there's German real property, German real estate. You can see that on the bottom of the page. And I don't need that anymore. Okay. German real estate, maybe here located in East Berlin, 3% vacancy rate. You have to pay a multiplier of 20, let's assume 20 on the annual net rent. It's a very stable cash flow you can acquire, because actually the majority of the rent is paid by the German social security system. And the foreign high net worth individual wants to invest in that real estate. What could he do? There are actually two alternatives available. The one is, you can see it on the slide, he uses a interposed corporation, here for instance a Luxembourg SRL, and that Luxembourg SRL directly invests into the German real estate. What is the advantage? The advantage is quite clear from a German tax perspective. There's only German income tax of 15.8%, the corporate income tax, and there's no additional income tax anymore. Usually a German corporation would have to pay additional trade tax, another kind of income tax of an average of 14-15%. And that trade tax can be completely avoided by using this structure. As an alternative, the foreign individual may also directly invest into the German real estate without any interposed Luxembourg corporation. However, then he is subject to personal income tax of up to 45% in Germany. Nevertheless, if he holds the real estate then for more than 10 years, he is able to get full tax relief for the capital gain when the real estate is sold. So these are the two alternatives which are available. The most common structure, you can see that here on the chart, is by interposing a Luxembourg or a Dutch vehicle, which also means that it is an intransparent structure, and the German tax administration cannot directly assess and cannot directly see the foreign individual behind that structure. From another perspective, what we have to discuss is tax liability. What I just said all relates to a limited tax liability. That means there's only taxation of German source income, here real estate income. You can see that on the bottom. That's limited tax liability. Similar to other countries, we have also unlimited tax liability, certainly, which results in a taxation of the worldwide income of that individual or of that corporation, subject to any double tax treaties which may be applicable or not. Unlimited tax liability can be assumed in case of three criteria. On the left hand, we have the residency for an individual, so let's say a domicile, a summer cottage, a flat which is owned and used. That all results in the residence of that individual in Germany. This is often underestimated, I think. So let's assume even every small flat, which is usable for an individual, or even every summer cottage, could result in this tax residency. On the right-hand side, we have the customary place of abode, which is on a case-by-case basis where there is no domicile. However, it still results in an unlimited tax liability, for instance, if someone stays in Germany for 6 months or more. In the middle, it should read actually registered office, not registered preface, registered office. That is for corporations, and when these corporations may become subject to unlimited tax liability here, I may address only one thing, and that's the place of management, because that's often decisive. The place of management is where the management takes the decision on behalf of the company. So, and not only the official management, even the factual management. So where are the people that decide on behalf of the company? That is the place of management, and that results, if the place of management is in Germany, in an unlimited tax liability in Germany. So what are the problems in this context? I may switch to this slide here, issues. Start at the bottom again with the place of management. Certainly you can use German subcontractors on behalf of the company that may advise. You may know these kind of structures from PE structures. Advisors that may advise but not take any decisions are only obliged to advise the management, and that actually decisions are taken abroad. There are these famous do's and don'ts list, which then needs to be fulfilled. That is very, very common, I think. On the other hand, for individuals, as I said, summer cottages could be a problem. And you have to know that the German tax administration is, let's say, quite aggressive in the last years. So if there's any indication with regard to an unlimited tax liability, often tax criminal proceedings will be opened, which then results in the fact that prosecutors will look for the credit card statements, will look for German mobile phones, fax machines, email traffic, and so on. So the German tax administration and the prosecutors, you have to know, are quite aggressive and really go deep into these kind of structures. What else can we discuss here today? Maybe one more slide with regard to compliance, tax compliance. In case of an acquisition in Germany, maybe in German real estate, you have to notify the German tax administration about that acquisition of the business. You have to fulfill and you have to fill out a tax questionnaire. You have to ask for a value-added tax return ID, and you have, of course, to submit German tax returns. That's a no-brainer. What are the consequences in case of non-compliance? Yeah, tax criminal proceedings, that's the worst case, and in particular, long period and long statute of limitations of up to 10 years or more. So taxes can be assessed for the last 10 years, including a 6% penalty interest for each year. Maybe, and I then come to the end of that short presentation of foreign investments into German real estate, 2 more sentences with regard to German real estate. That is maybe known, the transaction value of German real estate in the last years, including financial crisis. You can see that rising market. We are currently talking about, not yet talking about a bubble in Germany, but it's nearly a bubble, and we will see how that goes on in the next years. And what you have to be aware in case of a transaction in Germany with German real estate is the famous real estate transfer tax. I have here on this slide the real estate transfer tax, let's say the map of real estate transfer tax. However, it amounts to 3.5% in Bavaria and Saxonia, and up to 6.5% in some federal states. So 6.5% on the purchase price have to be paid as real estate transfer tax to the tax administration, and you will pay it because otherwise you don't get the legal title finally for that real estate. There are structures available to avoid real estate transfer tax, in particular in case of share deals. However, I'm not going to reveal these structures here.
And maybe then I can hand over also to Karl. I think he has similar issues with real estate transfer tax in Austria. So, I'm done.
Thank you, Hardy. Thank you very much. Carl, do you want to take over?
Yes, of course. Thank you very much, Alessandro. Just waiting for the remote control.
Yeah.
Thanks a lot. Good morning. We have already heard a few facts about real estate investments in Germany. I'm now going to continue and to walk you through some particularities about real estate investments in Austria. Maybe the first thing to start with is the very special things with Austria, with Austrian real estate investments, which is the fact that we do not have inheritance tax in Austria, which makes investments in Austria rather attractive for wealthy private individuals, having as a consequence, if you are invested in Austria and want to pass your assets to your legal successors, then the legal successors would not have to sell part of the real estate or the assets in order to cover the bill that they will get from the Ministry of Finance. So this is a very comfortable situation, which we have since 2008. It has been discussed whether this should be reversed, but fortunately there was no majority in the parliament. A very similar situation applies as regards donations. There is no gift tax in Austria as well. So just a notification obligation, which means if a husband, let's say, donates a car to his wife, there are two things: to hand over the key, that's the one thing, and even as simple as that is to file the notification with the tax authority just to inform them that this donation has happened, but no taxes.
Does that apply also to large estates?
This applies irrespective of the amount donated.
We should all move to Austria.
You should, but Italy is of course a nice place to stay as well. But I will refer back to this on the next slide. There is something which you have to pay if you transfer real estate by way of donation. But before I come to that, I would say a few words as regards Austrian tax residency rules. What makes you become a taxpayer in Austria? It's quite similar as Mr. Fischer has already explained as regards Germany. The one thing is to have a domicile in Austria, which means if you have a property, irrespective whether you own it or whether you have rented it, and intend to keep and use it, this could lead to Austrian tax liability. There is an exemption. This might be of interest for wealthy private clients who are not Austrians and think about going to Austria. This exemption is if you have lived 5 years abroad before you come to Austria and you had the place of your vital interest outside Austria, there is a kind of ordinance saying that there's a 70 days grace period. So if you do not exceed these 70 days, you will not be considered as Austrian tax resident. This is the one criterion, and the second one is the so-called habitual abode, which means if you, irrespective whether you have real estate in Austria or not, if you for some reason stay longer than 6 months, this would also result in Austrian tax liability. I would now come to the second part of the presentation, which deals with real estate investments. We have already heard for Germany there is a similar situation. What I've seen from Mr. Fischer's presentation is that Austrian tax level is a little bit lower. We have 3.5% real estate transfer tax for any kind of acquisition, both for asset deals and for share deals. There's only one exception where the tax rate can go down until 2%, which would apply within families. So this is also an advantage if a private individual invests in Austria. if this individual decides not to keep the property but transfer the property to his family or even his parents, then the tax rate would be 2%, and not calculated based on of the fair market value, but calculated based on the so-called uniform tax value, which is, I would say, 3 to 5 times lower than the fair market value. So you see, transferring real estate in Austria within the family is still quite cheap. As regards share deals, I said there is the same tax rate, 3.5%, but this can be mitigated. Usually it's crucial to acquire 100% of shares in a property owning company. This would trigger real estate transfer tax, but if you operate via a two-buyer structure, then usually this would not result in real estate transfer tax obligation. So there's also a possibility to transfer real estate free of real estate transfer tax. Item 2, continuous taxes. This can be cut very short. You might ask yourself whether it is expensive to own properties in Austria from a running cost perspective. It isn't. There is rather insignificant taxes, and I would say if you think about a family home which is worth 1 million, the annual tax would be, let's say, 1,000 euros. So this is not worth mentioning, actually. If you finally should decide to sell the property, we have some kind of new tax. It's a 25% flat tax on the proceeds, not on the proceeds, on the gains you generated by this sale. But there are some exemptions which would apply if you used the property for the center of your vital interests. Then there's even full exemption. So no taxes if you sell privately used property which you used for the center of your vital interests. Last but not least, some words as regards disclosure obligations. We have already heard a lot of AML and KYC things. This is actually the same in Austria, as 99% of all transactions are carried out by way of escrow assignments in order to protect the parties. You need necessarily to involve an attorney or notary public, which is subject, of course, to these AML and KYC regulations. This is one obligation to disclose information, and another obligation can result from land transfer restrictions. So if you acquire real property in Austria, depending on the province where the property is located, you might have to obtain approvals, and if you are a natural person, it's not difficult to identify who you are, but if you acquiring real property via a company, then you have to disclose the ultimate beneficial owner. So usually you operate via a multi-level structure, and you have to disclose who is the beneficial owner of this structure. This is also what Alessandro has already talked about. So this would be it in a nutshell from an Austrian perspective.
Thank you very much, Carl. Olivier, you ready?
Yes, I am. I don't need. I will do it the old-fashioned way without any slide. Thank you very much. Thank you for being with us today. I will try in the 7 minutes granted to each of us to explain you what is the Swiss special tax regime referred to as the lump sum taxation or the forfeit. What are the conditions to be fulfilled in order to obtain this special tax arrangement, and basically what are the advantage in choosing this special tax regime. Alors, the lump sum taxation system is basically a system by which, rather than being taxed on your income or on your wealth, usually worldwide, you will be taxed on a negotiated amount with the tax administration which is supposed to be your expenses. So to make a long story short, you're not taxed on what you make, you're taxed on what you spend. And there are certain rules to appraise your expenses, which I will come back very shortly thereafter. Once you have negotiated this basis on which the tax will be assessed, then the normal rates of taxes will be applied, depending whether the taxpayer is single, married, has children. The rate might change, and the rates will be the same as for a regular taxpayer. One of the main plus of this system is it reduced drastically the obligation of the taxpayer when filing his tax return. The only thing he will have to declare will be the amount negotiated with the tax administration and his Swiss assets, usually the home he will have bought to live in Switzerland, and income of Swiss sources. That's his only obligation. He does not have to declare at all, and it's not an obligation. Whatever he might have, assets or income of foreign sources. And even with this reduced declaration, he will be tax compliant, and the Swiss authorities will confirm that or deliver certification that this taxpayer fulfill all its obligation or its tax obligation under Swiss law. I come now to the condition to be fulfilled to obtain such a tax regime. There are not so many. First of all, only individuals are eligible to this tax regime and not legal entities. Those individuals, it's only open to non-Swiss nationals. So it's foreign individuals who are eligible to this tax regime. The next condition is the absence of gainful activity in Switzerland. In order to be subject to the lump sum taxation, the taxpayer must not engage in any gainful occupation in Switzerland, whether as an employee or as an independent capacity in Switzerland. But of course, however, gainful occupation abroad, not in Switzerland, does not preclude the lump sum taxation regime. I give you two examples. In the past 15 years, I negotiate quite a while of agreement for Formula One driver. They are working, but not in Switzerland. We have no Formula One race in Switzerland. It's forbidden. So they're living in Switzerland, they're working outside Switzerland, and it's perfectly fine. Another more serious example is the typical wealthy individual clients. He might have kept assets in his country of origin or in other parts of the world. He's living in Switzerland, he's not working, i.e. he's not on the payroll of any company or whatsoever, but of course he will continue to run the family assets, if you want, located around the world, not in Switzerland, and that also will not be considered as having a gainful activity in Switzerland. Then 2 words about the basis of assessments. I told you before, it's supposed to be the expenses, what you spend and not what you make. Usually, or very often, it's difficult for the tax administration to determine a verifiable amount of your living expenses. So what they are using is the rental value of your home in Switzerland. The rental value is, well, if you rent a place, then it's easy. It's what you will pay on a monthly basis. If you own the property, they have a different calculation which is more favorable than if you rent it. But you're deemed to spend 5 times the rental value of your home. It was 5 times until the end of this year, and as from 1st of January next year, it will turn to be 7 times. And your deemed expenses will be 7 times the rental value of your home in Switzerland. That's basically the approach they have. I need also to add we had in November last year in Switzerland an initiative coming from the Socialist Party in Switzerland to cancel the forfeit or lump sum agreement in Switzerland, while normally this is a matter for the cantons to deal with. Hopefully the people were smart and rejected this initiative by more than 60%. There are a few cantons, mainly Zurich and Basel, in which you don't have this special tax regime, but otherwise it remains in most other cantons of Switzerland. There is, however, a big difference between those who will, of course, to get that special regime, I forgot that, you need to become a Swiss resident, take residency in Switzerland. And there is a big difference whether the applicant is an EC national, a European national, or not. Because for EC national, Switzerland has bilateral treaties with the European Community for free circulation of persons. So any nationals of the EC community, as a matter of law, will be granted a residential permit in Switzerland. While for non-EC nationals, like our Russian friends, for example, they will have to prove either that they have previous long-term ties with Switzerland, which most of the time it's extremely difficult. By previous ties, it means that they have been at school in Switzerland, or they spend in their life already a couple of years in Switzerland. So that's not available in most of the case. And the only other way it is to show that the granting of your permit will have an economical value for the country. And that's basically the reason why this major public interest test, if you want, will, for the non-EC national, increase the amount of the forfait. For the other one, 7 times the rental value, but for non-EC, in order to have the support of the tax administration, which will support the permit application, saying it represents a major public interest to grant that permit, they will increase it. They will apply this now 7 times yearly rental value, plus it has to be negotiated from a canton to another, but by experience, especially Geneva and Vaud, which is just next door, have the tendency to be a bit greedy, and they increase the basis by almost 500,000. I don't want to bother you with figures of how it is calculated and so on, but just to have an illustration, if the taxpayer married 2 children comes and buy a house worth, let's say, 10 million Swiss francs. Real estate is expensive in Switzerland. if he's an EC national, the assessment of his expenses and the basis on which he will be taxed will roughly be between 900,000 and 1 million. For a non-EC national, it will goes up to 1.5, 1.6 million. And the amount of tax to be paid on those figures, around 1 million, again, it depends in which canton, in which place, whether you're married, children or not. But around 1 million, it will be between 36, 38%, and at 1.5, 1.6, it's more likely to be around 40%. Just to give you an idea, without going into too many details, because then it's a case-by-case basis. To sum up, the main advantage, again, it's no obligation to declare the foreign assets and the foreign income to be tax compliant. Switzerland is still a safe and nice place to live. With children, they have, good school, good education. And if Switzerland is a nice place to live, it's always, and I jump on what has been explained by my Austrian colleague, it's also a nice place to die. Because you have, it's again in each canton. In most of the canton, you have no inheritance tax and also no gift tax between spouse. That's the general rules everywhere. But in most of the canton, you have also no inheritance tax at all between parents and children, whatever the amount. In certain cantons like Geneva, like Vaud, you still have an inheritance tax for those who during their life benefited from the lump sum tax arrangement. Basically, they make you a favor during your life and they try to recoup a bit at the end. But still, we're talking the maximum succession tax in Geneva, it's roughly 5%. In the Canton de Vaud, it's 2.5, it's half of that. So we're not talking about, I don't want to qualify that, I want to remain polite, but what they will take in France, for example, they steal you 45% at the end of your life. So it's not within the same range. So the lump sum taxation regime still is, I guess, a very attractive solution for wealthy taxpayer, given that the ordinary tax rate will only apply to a portion of their worldwide income and assets, with, of course, a tax burden significantly reduced. On Switzerland being a nice place to die, I need to, and I will close with that, just open a parenthesis. All what I told you is true today. It might not be true 2 weeks down the line. We have a new initiative. We are voting on it right now. The voting by correspondence started 2 weeks ago, and the result will come. I'm talking under the control of my French colleague on my left, on the other side. I don't know whether it will be this coming weekend or the next weekend. It's a couple of days or 10 days down the line. It's an initiative by which the socialists want to have a 20% inheritance tax on all estate equal or above 2 million Swiss francs. And it's supposed to finance our social security. So it's a quite appealing package. But in spite of that, the latest forecast, it's very likely to be refused. Switzerland is a strange country where you have to ask people whether they want to pay tax, and they can say yes or no. So hopefully, like for the suppression of the forfait which has been refused, I hope that my people will be smart say no to this new tax and keep Switzerland as a nice country to live. Thank you very much.
Thank you, Olivier. We'll now hand over to Silvia Chietko. I'm sorry, of course, yeah. Yeah, we're now switching to investing, and Martin Lewis will go on first.
Thank you, Alessandro.
Sorry, Martin.
Yes, thank you, Alessandro. I'll first of all make some comments about offshore trusts and international trust law. Now, the great majority of offshore trusts are what we call sham trusts. That means to say that international trust law authorities and courts will not recognize them if they examine them closely. They are often little more than glorified bank accounts. Having regard to the importance of designing international structures, of which trust can be a component, I make no apologies for going back to basics in better understanding trusts and how they should be used, particularly because trusts, as we all know, are a very alien concept to civil law jurisdictions. Now, to do this, we need to understand what the sources of international trust law are. And the briefest history of trusts helps you to anticipate what international trust law very probably provides without going to the textbooks first, and which essentially means an understanding of the roots of English trust law. If you understand this, trust law is actually quite easy. Now, ancient Rome developed the concept of trusts on death, but it was in England and in the 12th and 13th century that the concept of trust created during a settler's lifetime emerged. A settlor is somebody who creates a trust. And it was in response to the practical problems this law developed at that time when warriors went to war on crusade in the Holy Land, and they left their property and affairs in the hands of their brother or uncle under the expectation that when they returned to England, they would get their land back. What actually happened was, many of them, when they returned to England, the brothers and uncles refused to hand the land back, and so they petitioned the king. The king said, "I'm not really interested, go and talk to my Lord Chancellor." And the Lord Chancellor exercised his conscience, because common law said, no, this property was transferred to your brother or your uncle, and we recognize no obligation to hand it back. And the Lord Chancellor, exercising his conscience, developed equity. So the two strands of the English legal system are common law and equity. And equity developed in response to this historic problem about dealing with property in the 13th century. Now, that might sound very remote, but the reality is that whatever duties, responsibilities, and obligations you would like to have your unreliable brother or uncle to have whilst you're away are still the laws that apply today. So if you want to think what the duties are of a trustee and what he might have to do in a particular situation, imagine yourself as a medieval knight worried about your property and what's going to happen when you get back in England. This history also explains the key characteristics of a trust, which is that they're not entities. They're a bundle of fiduciary duties and personal obligations of natural persons who are the legal owners of properties. So it's very important to understand this. A trust is not an entity. It sounds like an entity, but it isn't an entity. And the property is owned by trustees, and the trustees have duties towards the beneficiaries of the trust, but no duties or obligations to the settlor, the person who created the trust. And it amazes me in an international context very often how very rich people are quite happy to hand extensive property to trusts on the misunderstanding that it's an entity which they can retain some sort of control over. That is not the case. Now, we move forward rapidly to the 16th century, to just before the Second World War. And during this period, land law and trust law grew together as trusts were used to control land and dynastic succession within local families, mainly because women couldn't own property until the 19th century. So if you had a farm or an estate in the family for centuries and you only had daughters, you wanted to make sure it could skip a generation and go through. Similarly, if you had a title, a noble title, and you want to keep the title and the land together, you would very often use trusts. If you had a spendthrift or irresponsible son who you didn't trust, again, so that it could skip through to the next generation. The amount of property owned by English gentry families until the First World War was over half. It is now 1%, and we have had a revolution in land ownership in England, which nobody has noticed, but it means that trusts are domestically little used, apart from on death, in wills. Now, moving forward a little further, as a merchant and imperial power, England took its law informally and formally to those of its territories that had no existing sophisticated legal system. And then on independence of each part of its empire, England left each country with legal constitutions and codes which have substantially developed in parallel, and so embedding English trust law throughout the former British Empire. The exceptions to this, the main exceptions, are India, which, because it had a sophisticated system of its own, the English never interposed. And then, of course, there is America, which has since long gone its own way, since it has escaped England's grasp, and is now so remote from the international law of trusts as not even to be relevant by analogy. Now, from the 1960s, former English colonies were encouraged to develop trust and financial services to provide for their economic security in future, and in small countries predominantly without resources other than at best perhaps limited tourism. It was during this period that the concept of layering or using different levels in the same structure emerged on behalf of ultimate beneficial owners, and allowing for new levels of sophistication in tax planning by effectively arbitraging legal and tax systems. The offshore trust concept, which emerged from this extended history, are normally created in the settler's lifetime and are mainly used for securities, cash, and movable assets, and not land, and usually only relevant to those overseas rather than those domestically who wish to use them. The last period of rapid development was the 1970s, particularly in England, when we had the use of international trusts in response to very aggressive socialist taxation policies in England in particular. We forget now that there was a brief period in the 1970s on particular types of income where the effective rate of tax was at over 100%. Over 100%, and this provided an enormous incentive to lawyers, accountants, and tax advisors to be creative. It's interesting that in these jurisdictions with an English legal heritage, they began to and now cite precedents in local, as if they are local law rather than foreign law, and which has further helped the development of an international law of trusts. Also, of course, electronic methods of communication also encourage convergence. To turn to civil code systems by comparison, non-common law systems uninfluenced by the English model, as you know, do not historically include the trust concept as part of their systems, and they are essentially alien. However, to compete for settlers and their advisors, some of those systems have introduced their own trust law based broadly on the English model. And I can think of Brunei, Dubai, and San Marino in particular, and most recently Curacao and the Netherlands Antilles in 2012. First world countries, such as France, have also introduced their own version of the trust concept, and based on contract rather than the English law of equity as developed in the medieval period. Now, the reason why I tend to prefer English trust law is because the judges who are required to interpret and apply it have enormous experience, and they're able to rely upon hundreds of years of evolved precedent in order to guide them when they're unsure about what a proper decision should be. Now, this is probably unfair, and I will be corrected, but in the civil system, there is always the risk that you will get a professional but reasonably inexperienced judge interpreting very broad principles and without recourse to the enormous library of precedent with which to guide them. And that, I would say, is a weakness of many civil systems and the strength of the English common law and equity system. Now, the legislation for these non-common law countries tends to have greater differences between those with English roots because they generally respect the express provisions of the trust instruments. Such instruments tend to very closely reflect the English tradition in any event. So even if you have a civil law trust jurisdiction, they tend to use essentially English trust instruments in character and shape. Now, the way that the international law of trusts has developed has also been strengthened by the 1985 Hague Convention on the law applicable to trusts and on their recognition, and which does not introduce or change the domestic law of ratifying countries, but which provides for recognition of the concept constituted under any foreign law with choice of law on the matters to be determined. The English trust law model therefore predominates in international trust law, and which further reflects the English training of many lawyers active in this area of the law. English lawyers local in most offshore jurisdictions, and English judges in many courts of former English colonies, and the fact that the English Privy Council is the ultimate court of appeal for many such jurisdictions. However, the competition of various jurisdictions has led some of them to go too far, with, for example, the excessive reservation of powers by the creator of the trust still trying to control what he has given away, but mentally still regards probably as his. Also, the exclusion of foreign law and the aggressive protection of assets from creditors are proving controversial in some of the more peripheral jurisdictions available. And this is leading to pressure led by the G8 on these jurisdictions to conform and to moderate their excesses. It's the rising public consciousness of and the public response to industrial scale tax evasion, and how evasion is now being mixed up with perfectly legitimate tax avoidance that is now feeding through to public policy throughout the first world. Now, the good long-term advice that we in this room should give to our advisors is not about what games you can play with words at the moment for the advantage today, but to predict long-term trends so that we can put our clients in the best position that they can be with regard to how things develop in 10, 20, maybe 30 years. And that's why, rather than being specific in the comments I'm making, I'm talking about the latest trend in the tide of history. Now, from these two different paths, the English and civil law alternatives and how they meet, a true international law of trusts has emerged, and which is stable and which has the level of predictability that is an essential part of intelligent planning of solutions for clients' requirements. The law of international trusts is a genuine international law, unlike many areas of purported international law. And to my mind, and that of many, is the greatest achievement so far in the development of international law outside that of human rights. Now, of course, there are limitations, and it remains the case that there are limitations with respect to the use of international trusts and reflecting that they are more demanding than companies. This is because companies have no conscience, are essential amoral creatures of statute, and cannot be put in prison. Trusts, on the other hand, are a bundle of personal duties and powers imposed on and exercised by natural individual persons, and who are able to exercise various degrees of discretion. Trustees own the property, and there is no such entity as a trust. Therefore, trusts compared with companies place much heavier obligations on trustees, who can be personally liable when compared to the obligations placed on directors. And the trustees' range of legitimate discretion means that there is greater room for disagreements and disputes between the people who create trusts, wrongly try to retain some degree of control over them, the trustees and the beneficiaries, and how the trustees exercise their independent powers, and therefore perhaps creating a greater potential for disagreement and litigation, and again emphasizing the need for bespoke trust instruments rather than relying, as in the majority of cases now, on very often inappropriate off-the-shelf standard solutions which are slotted into otherwise sophisticated planning arrangements. Now, it's also the case that the Hague Convention does not displace local procedural law, and the application of which may lead to different outcomes from what might be anticipated under international and its underlying English trust law. That divergence might also be conscious by the local jurisdiction in distinguishing itself from competing jurisdictions. A final comment with regard to whether there will be a trust law in Russia. There has been a debate in Russia about introducing its own form of the trust concept since the 1990s. And very recently, the Russian government is consulting again in this regard, and presumably as a political solution to the practical issues that have arisen from the natural competing interests following Russia's controlled foreign companies legislation and how to impose it and those that wish to resist it. Now, is a trust law in Russia a good idea? I can only say as an outsider that the practical consequences might be that the state, in common with the experience of other states, will not have the resources to properly police these arrangements. And so those arrangements will very quickly be abused, and there being a difficult period for trusts and their adventurous use when government eventually catches up with them. Domestically, the obligations placed on trustees, who are individuals, are also perhaps so onerous that the concept may be little used and nobody wishing to become trustees. And so this will not provide any real long-term solution. So the point is that if you have a basic understanding of and a respect for this simple history of trust law, you will be better placed to use them effectively for your client's benefit. Just imagine yourself as a medieval knight. Thank you, Alessandro.
Thank you very much, Martin. Now it's time to let Silvia give us his presentation, please.
Okay. Many thanks, Alessandro. Hello, everyone. My name is Silvia, and I come from Wolftais, Croatia. The topic of my presentation is real estate investments in Croatia, but let me start off by saying that I'm really very pleased to be here, and that over the last 3 days I have met so many wonderful people who either had great holidays in Croatia, or honeymoons, or have done some business in Croatia, or are considering starting business operations here in Croatia. And Before going into the presentation, I think three things are also important. The first is that Croatia is actually the youngest EU member state. We joined just 2 years ago. Then, to give you like an overview of what the most important sectors for the GDP in Croatia are, let me tell you that 20% of the revenues of the GDP is actually being generated from tourism. So hospitality sector is really extremely important. And the third thing would be, it's not always easy to do business in Croatia, but still you can do it. A few general remarks on acquisition of the real estate in Croatia. Well, it all depends who is the purchaser. I mean, obviously, being an EU member state, so there are the same rules for EU citizens and the companies based in the EU member states as do apply for the Croatians. There are two exceptions. One is still the acquisition of the agricultural land, and the other would be like a real estate proclaimed as the protected nature areas. When we come to the non-EU citizens or the legal persons, the rules are slightly different. So actually, you would first need to have this reciprocity. And once this criteria has been met, then you still need a prior approval of the Croatian Justice Ministry. So this procedure can be time-consuming. And again, there are some exceptions. Even in such cases, if a foreigner would like to purchase a real estate in Croatia, this is not always possible with regard to agricultural land, forest sometimes, or just the real estate that is of huge importance for the national interest of Croatia. I would say that the real estate market in Croatia is still very attractive. We have done a lot of transactions also for our Russian investors and clients who do buy very nice villas on the Croatian islands, or really who decide to start business operations there. I already mentioned that some special rules do apply when purchasing like forests or agricultural land. There are still some other special land regimes where you can actually, even when no one can acquire a real estate, which would be like the case with a maritime domain, sometimes very important on the coast. So with regard to maritime domain, only things that's possible is to be granted the concession, right, so that you can use it. Sometimes you have to be careful with culturally significant real estate, and always be careful if you consider, acquisition of hunting grounds or similar real estate. Of course, as with any project, there are always challenges to purchase real estate in Croatia. That's why we would always strongly recommend to do a proper title check. And as the change from, let's say, the communism social ownership system in Croatia to the private entrepreneurship, the Western style system and the economy occurred, let's say, 25 years ago, you also always have to be careful if you have a land that used to be social owned. So in such cases, a special care is always required. Obviously, when you buy a land, most of the time you want to build on something. So it's always very important that you know what are the current local rules and what actually can be built, just to avoid the problems on later stage on your project implementation. I won't go too much into details regarding the tax regime, but just a few words. So basically similar as to the system in Germany and Austria that Hardy and Carl already presented, we have a 5% land transfer tax. However, recently, as of the 1st of January of this year, our tax regime was adjusted to the EU rules. So also the VAT at the rate of 25% can be applied upon. And in the end, it all comes on what property do you buy? Do you buy, let's say, just a building, or would you buy like a land? And then if it's land, if it's like a construction land, or if it's other kind of land. So basically now, purchasing a building, you would always have to pay VAT at rate of 25%. And with regard to construction land, construction plots, then you would have to be, careful and see other land plots. What is actually the usage of them sometimes? So, and that's why, of course, we would also recommend to have a tax advisor supporting you on the transactions in Croatia. I will finish with a brief outlook and maybe just pointing out to some business opportunities to foreign investors in Croatia. And first I'll mention that mid of February in 2015, there was a very successful Russian-Croatian business forum that took place in Moscow, attended by more than 300 guests. So that was a platform that offered great opportunity for exchange for the Croatian, European, and also the Russian companies. And it showed that beside real estate sector, the foreign investors are also interested like in chemical industry, shipyards, automobile, and what I mentioned at the beginning, I mean, hospitality and tourism sector. So this brings me to the end of the presentation, and I'll be happy to answer your questions later. Thank you.
Thank you very much, Sylvia. Okay, now we're through with the lawyers, and it's time to hand over the talks to the real business, and therefore to bankers. Andrei Babian.
Thank you.
Thank you. You're going to speak in Russian, or?
Yeah.
Okay.
Thank you very much. Good morning, my dear colleagues. Excuse in advance, my presentation will be on Russian language, and I'm kindly ask you to take your headphones, of course, if you need it. Thank you.
My presentation is called Current Situation in Wealth Management, but before I proceed with my presentation, I see that we are having a rather lengthy session today, and I see a lot of you are starting to look tired. So I would like to tell a small anecdote about this legal forum. Several years ago, when I took part in the legal forum in St. Petersburg, following a session, I joined my colleagues for lunch to one of my favorite restaurants, which I visited 2 weeks prior to the forum. So when we opened the menu, and we saw that the prices in the menu are completely outrageous, and everything is much more expensive. So when I asked the waiter what happened to the prices, why are they so high, the waiter looked at me and he said, what, do you understand that we have a legal forum in St. Petersburg? There are such distinguished candidates there, so, we increase the prices to honor them. That's why I'm extremely pleased to take part in the forum, so that I can understand what sort of influence and power it exerts over the entire city. But now, moving to my presentation, so current situation in wealth management. Well, I chose this topic while we were talking about current or wealth management, because we cannot just set up a process and stick with it and move in the same direction. We see that the market, the jurisdiction, the tax law, the legislation keeps changing. Well, it means that the demands of your wealth management clients will also change. We will have to think about main directions for their investments. So we have to be flexible, and we have to be able to give our clients what they need here and now. That's why I call it current wealth management. But since we are at the legal forum today, I will tell you about what sort of legal services we provide and how we usually find solutions together with our clients. So let me just give you a brief introduction about the company. Alpha Capital is the leader in the Russian market when it comes to the wealth management. It is an investment branch of Alpha Group. And if I give you a couple of figures, in 2014, our revenue was 1.3 billion rubles. We have more than 1 million clients, and we are managing their assets. I would also like to underline what's very important for us is that the average time we have worked with one client is 6 years. If I start talking about Alpha Capital Wealth, basically this is a wealth management department of Alpha Capital. We have a loyalty program which has been running for 5 years, and if we talk about our wealth management clients, well, we have more than 1,000 clients with the average value of their wealth slightly over $1 million. So we have about 120 requests that we receive from our clients every month. And we have more than partners who help us do our job on a daily basis. So Alpha Capital Wealth was created due to the Russian practice. You know, when usually a private bank is created, they would publish a 600-page booklet with all of the discounts from restaurants and partners. I don't know whether this booklet is needed, but usually when you do come to a partner, it turns out that there are no privileges or discounts. So Capital Wealth is for us, it means that we're not talking about 5,000 partners, but we are talking about partners so that we verified, we check their performance. And when we were setting up this loyalty division, we would first ask about our clients, about their needs, so that we can better determine who our partners could be. On this slide, you can see the main directions for this program. Of course, we provide bank services, and we also cover daily needs of our clients, such as insurance, real estate, jewelry, medicine, and tax consultations, and so on and so forth. But if we talk about more frequent requests that we receive from our high net worth individuals, well, usually we deal with selection and purchasing of real estates. We provide taxation consultations. We provide services that help them to open accounts in different banks in different jurisdictions. We assist them in their children's education. We assist them in inheritance issues, in trust issues, and we also assist them with structuring of their assets. So when we talk about the structuring of our assets, it is becoming a more relevant issue for our clients that we assist them with. And if we talk about Russian clients, first of all, our clients are concerned about the legislation and the probable difficulties that they might have in terms of the legislation. They also want us to offer them tools. That is why today I would like to tell a little bit more about one of these instruments that we offer to our clients, an instrument which helps solve our clients' asset structuring problems, while at the same time making them compliant with the law. So one of such instruments is a closed mutual fund. So it's a closed mutual fund where no legal entity is established. And here I would like to underline that regardless of what it is that we're investing in, whether it's equities, bonds, art, rental business, summer cottages in different countries, as you can see, what I have on the bottom, well, basically all types of investments that can be used. But why is this closed mutual fund useful for us today? Well, if our clients have foreign assets, for instance, so they have a chain of hotels in Croatia, in Germany, in Italy, then under the law for foreign-controlled entities, you can transfer these assets to the closed mutual funds, and then under the law that allows us to ensure that the property is protected. And even if you are getting a divorce, which is very important, unfortunately this is a situation in our real life, a lot of our businessmen, a lot of our clients do end up getting divorces, and even when our clients divorce, the property is protected as part of this closed mutual fund, so it wouldn't be so easy to divide this property. It also allows to control the investments into such closed mutual funds, and the most important issue is, of course, taxation of the fund. The mutual fund pays all of the real estate taxes of our high net worth individuals, but if we're talking about their business, which brings them income every month and every day, well, it means that our clients do not really pay an income tax. They only pay income tax only when the closed mutual fund is dissolved, when you decide to take your assets out of it. So here what's very important is when the law on foreign controlled entities was accepted, the closed mutual funds are becoming more and more popular for our high net worth individuals.
I've been talking about the instruments that we are providing as a company, but of course we all want to discuss how could we combine the legal practice, how we could help each other. This holy grail of three solutions allows us to resolve issues of our clients. We work and improve our loyalty to the customer, and we help you with your clients. Alpha Wealth has got partners who help resolve various legal issues. This is the slide that describes how it happens. So we get a referral from our customer, or a question rather, be it assets, taxes, whatever. Then we look who could be best positioned to help to our customers, so we make a referral. So as a result, we retain the loyalty of our customers. You as lawyers get referrals from us, you get business, you get practice, and you help our customers, our clients. So apart from investment missions, the wealth management that deals with various investments, protecting property, but you also need to structure assets, and it is more complicated, more sophisticated issue, so that our customers and clients, be whatever that happens to them, divorce or bankruptcy, they would have their property protected. Thank you.
Thank you very much. I see that we have maybe one question.
Alessandro, a short remark, if possible, because Mr. Andrei has mentioned the Russian WorthNet individuals, and I would like to mention the novels in Russian inheritance law, because just a few days ago, maybe 3 days ago, actually, the novels in Russian inheritance law were brought to the State Duma, and maybe that would be very interesting novels, because it may help to structure the business and the assets of Russian individuals, because the previous law in Russia was not very flexible, and these drafts and amendments bring more flexibility in this aspect, because Russian testaments under conditions were successfully contested in courts, and now this bill gives a right to make such testaments, and gives a right to enter into the inheritance agreements and gives right to make a kind of foundation or a trust to manage the property which will be inherited by Russian individuals. And there is very interesting drafts, and maybe it would help and bring more flexibility in Russian inheritance law.
Thank you. Yulia, do you want to comment on this? You're the Russian lawyer, you're the Russian expert.
This law is a long-anticipated law, and we all hope that thank you. This draft is a long-anticipated draft, and we all hope that it will go through very smoothly, and it will work for our clients well. So it's nice.
Thank you very much. So we'll keep our fingers crossed. Last but not least, now we'll have Dmitry Galkin from Gazprom. Dmitry, could you please start with your presentation?
Спасибо большое. Моя презентация также...
Thank you very much. I will use Russian with your permission. I'm coming from Gazprom Bank, and people tend to call us Gazprom all the time, but we are in fact part of one of the systemically important banks. We have, as a result, have extended duty to our clients when we work on our own proprietary instruments and services, and when we work with our clients, we need to keep up with the swiftly changing law in Russia and abroad. Gazprom Bank Private Banking is a department or an entity that's been on the market for over 2 decades. We have a strong regional presence across Russia. Our headquarters are in Moscow, and starting last year, we are now offering our clients services rendered by our subsidiaries in Switzerland and Luxembourg. So things that we do for our clients are strictly in compliance with the Russian legislation and the law applicable to Switzerland and Luxembourg. Working with high net individuals, given the rapidly changing environment in the post-crisis world after 2008, we all know financial regulators all over the world are creating more and more complex conditions and settings for banking and for asset management, and this of course applies to Russian individuals. Tax authorities all over the world and in Russia do want to increase the efficiency of the fiscal initiatives. Banking regulators working very hard, and we heard from our colleagues, and I agree with them, as far as the compliance and due diligence procedures are concerned as part of the ALM. These compliance requirements getting tougher and tougher. Well, some people say there is no notion of compliance in Russia, but it is not true. Russian banks work very hard to vet the sources of revenues of our clients. So everything that's happening globally can't but affect our clients, and since we are working long-term with our clients, we want to preserve our long-term loyalty. We also want to be thorough in our due diligence and services and products that we offer. We need to respond to the demands of our high net worth clients. Just to give you some understanding, according to our analysis, over 70% 70% of our client base has been staying with us over 6-7 years. That is, net worth individuals feel protected by Gazprom Bank, and our private banking allows us to offer personal structured products and services to our clients. Again, talking about the interactions we have between ourselves and the legal advisors, this process is constantly ongoing, and the number of referrals, the number of queries from our clients has been growing in a geometric progression. 5, 6, 7 years ago, we had only a few of such queries, and we had to work case by case. Today, the number of queries, because of the rapidly changing Russian laws, for example, in the law on foreign exchange, which applies to individuals, and then this law on the controlled foreign companies, all that moved us at the department to set up a separate tax legal practice. And of course, we were very thorough in selecting our partners because we are quite confident that the number of legal advisors that could help our clients cannot be infinite. And the key criteria in the selection of partners, of course, are the reputation of a partner in the market, the quality of services, flexible pricing for our clients, and in particular, we were selecting our partners based on their individual and specific expertise so that we could have the entire coverage of all possible legal issues that might emerge. When we work with our clients, trust and confidentiality are the two pillars, the two key criteria. When we structure work with our partners, we do not refer our clients straight away. We try to keep up with our client from the very first query to their demand throughout through the range of demands they may have in terms of various legal services. So we are there for our clients. We monitor the quality of services offered by our partners, and significantly, of course, we always seek to get the feedback from our clients and from our partners after the service has been rendered. As a result, we are better positioned to understand what our clients want, and we could structure better our relationship with the partners. With our partners, of course, we have mutual interests with them. If I'm to comment about the most interesting issues on the Russian markets, my colleagues here mentioned the key forthcoming amendments and the more needed services is the assistance in tax declaration. With this law of controlled foreign companies in force, our clients will be asking more and more questions. As far as taxes are concerned, we need to be prepared to offer them professional assistance. And the same is true of the mentioned laws on inheritance or on controlled foreign companies. The issue of inheritance in Russia is very pressing, very relevant, particularly going forward 10 years in the future, because as you would remember, most of the capitals were made in the 90s, and those who used to be the creators of the family fortunes will be soon retiring, so they will start thinking how best ensure effective transfer of their assets to the inheritors. So the profession of the tax advisor may be a good job to have in Russia going forward. So those of you who may be thinking what you want to do in law, those of you who want to help with legal practices, this is a good area to practice in. Some of our clients also ask questions about investments in real property abroad. Our clients often approach us with their questions. They may be needing advice, who to trust, where to go, and they come to us because we believe in trust and confidentiality when we work with our clients. Based on the queries that we get, we have a good understanding who of our partners could provide the best service. And in particular, one of the queries that I wanted to comment in more detail had to do with accounts held at foreign banks and owned by Russian residents. So we've heard from Yulia Chekmarova about this issue, and we have this notion of, in the Russian law, as the so-called foreign residents. We have tax residents and foreign residents for tax purposes in the Russian law. As a result, Russian net worth individuals tend to ignore this fact. They may not be aware about this notion. Some of our Russian residents who tend to reside abroad.
Do you want to finish your talk?
I need just 1 minute to finish. Tax laws, compliance, and issues of compliance in Russia allows us to source out to our subsidiaries and our partners abroad. They offer protection as well as compliance with Russian legislation, and as a result, we will continue being loyal to our clients. Thank you very much.
Thank you very much. Thank you very much, everybody. I don't know whether we have time for some questions. Zero time? Okay, so Dmitry, it was not just you, it's all of us. So, well, thank you again for organizing this, and thank you to all of our distinguished panel speakers. Goodbye.